Hi, my name is John Markham, and I'm an attorney with LegalShield's legal provider firm, Wagner Falconer Judd in Minneapolis, Minnesota. Today we'll go over some of the basics of estate planning, and I will walk through what estate planning is and why you need it. I will also explain common estate planning terminology that some folks can often find confusing. What is your estate? Put simply, your estate is all the assets that you have accumulated, or in other words, it's your stuff. That includes everything from the home that you own to the lamp and couch inside that home. It includes your bank accounts and anything that you have an ownership interest in, such as a business. In short, it's anything you own that needs to go somewhere in the event that you should pass. The three main goals of estate planning can be summed up as follows: to manage your affairs during your lifetime, to distribute your estate after your death, and appoint a guardian for any dependent children or caretaker for any pets, and to minimize problems for your loved ones after your passing. Most of us don't want to consider that our family could fall into tension or anger after our passing, but unfortunately, that is more likely to happen when the family does not have clear direction in the form of a will or estate planning from you. This is why it is important to have some plan in place to ensure your family has a smooth transition to administer your estate and distribute your assets. If you don't have a will, a third party, such as a judge, will be making those decisions for you. The purpose and need for estate planning. Estate planning allows you to make your wishes known to who is to receive your assets, who will administer your estate, and who will be the guardian of your children or caretaker of any pets. This can all be accomplished through a will. You can also make your wishes known for life-sustaining treatment decisions with a physician's directive, also known as a living will or healthcare directive. A power of attorney allows you to designate an authorized party to address issues related to financial matters on your behalf while you are still living. Common estate planning terminology. Intestate. Dying without a will is often called dying intestate or intestate succession. Each state has its own laws on how assets are distributed if no will is in place. A court will decide who will be the beneficiary of your assets and will appoint a guardian of your dependents. Your loved ones may also face fees that are usually higher when having to probate without a will. Power of attorney. A power of attorney allows you to authorize an individual to act on your behalf to make certain decisions while you are still living. Power of attorney can be general, authorizing your agent to conduct all acts, including financial transactions and property management. It can also be limited, authorizing your agent to conduct only specific acts or make certain decisions on your behalf. You can direct that the person act on your behalf immediately, or that they act on your behalf only if you become incapacitated or no longer able to make decisions. A healthcare directive. A healthcare directive, sometimes called the physician's directive or a living will, is a legal document related to life-sustaining treatment decisions and allows you to make your wishes known regarding end-of-life decisions. Specifically, it allows you to designate a third person to make healthcare decisions for you if you are unable to do so or are otherwise incapacitated. A personal representative or executor. This is the person who is in charge of handling your estate and wishes as documented in your will. It should be a person that you trust, who will gather up all the assets of your estate and make sure that things get where you intended for them to go. Beneficiary designations. These types of designations actually allow assets to pass outside of your estate, regardless of what's notated in a will. Life insurance is perhaps the most common example of this. Upon your passing, a life insurance policy that you hold will have a beneficiary that has already been designated. Upon your death, that amount becomes pay in dual to the individual who you designated. Jointly held assets. These are assets that are held in the names of two or more people, and assets held with a right of survivorship pass automatically to the survivor upon death of the other owner. The most common example of this may be a joint bank account. If one owner of the joint bank account should pass, full ownership and control of that bank account passes to the survivor. A LegalShield family plan provides preparation of a will for both you and your spouse. You can even start the process of preparing your will right from the LegalShield mobile app. If you are married, your spouse will need to create their own will. Each state has laws related to these estate planning documents and issues. If you have any questions about your specific estate planning needs, you should speak with your LegalShield provider law firm in your state directly.